Good afternoon, everyone. My name is Brianna Bogan. I am the Director of Legal Services, and during this Lunch and Learn today, I'm just going to talk to you briefly about the importance of a last will and testament and some other advanced directives that you may find beneficial as far as a healthcare power of attorney and durable power of attorney. So before I start going through what is a last will and testament, does anyone currently have a will in the audience? Is it updated? Okay. Who in the room knows they need a will and would like to schedule an appointment with us? I hope to change you all's mind. I want to see more hands. Okay, so a last will and testament is a written document, and what that document states is how you want to leave your assets. This is personal assets, so these are cash accounts, your tangible items. I like to tell people it's anything that you can throw on a trailer and move. So anything that is personal to you, you can designate that as well as your real estate, so that's your land. Also, this is the Landowner Symposium. Your last will and testament can also include references to your forest management plan, and that's something that we want to make sure that we are emphasizing. Is we want to talk about the opportunities that you all have with building your business, but also protecting your legacy. So this is what your last will and testament does. So as I stated, a last will and testament is a document. It is written by the person that has that asset, and they're naming a personal representative. So that personal representative, or some people may know it as an executor, will be that person that's responsible for making sure that your will is filed with the court and your assets are distributed to those beneficiaries that you listed. Also, the will talks about the powers of that personal representative and how they must maintain those assets for the benefit of those beneficiaries through the probate process. So again, you list out your personal assets, so cars, jewelry, books, and your land. So this is going to be your residential, it's going to be agricultural. It can also allude to any heirs property you have. So it doesn't matter if you have a fee simple or 100% ownership interest, or you have a fractional interest that we discussed regarding heirs property. Any and everything you have title to, interest in, needs to be included in the will. And you want to be very specific to what those assets are. That will is then witnessed by two disinterested witnesses, which means they do not have any rights to inherit from your estate. So this is something that's very important, that you don't want your will to be invalidated because you've had one of your beneficiaries witness to your will. And then it is notarized. Although it is not a requirement for wills to be notarized, it helps it become self-proving. And so in our office, we do offer that service. It's $50, but also if you're over the age of 80, it is free. We offer them in our North Charleston Opportunity Center office, also in Orangeburg. We have a couple of wills clinics coming up. We have one November 5th in Allendale, and then we have upcoming October 15th in Jasper County. So please, after lunch during our break, if you want to speak to me about registering for either one of those, that would be great. I would love to see you all there. Now, a healthcare power of attorney is a document that talks about your healthcare needs. This document is important because in the event that you do not have capacity to make those healthcare decisions, you've elected an agent to speak on your behalf. This is something that's very important regardless of what age you are, because anything can happen, especially as we've seen through COVID. So your healthcare power of attorney is another document that we do in the office that, again, addresses your healthcare needs and elects an agent to act on your behalf regarding those healthcare needs. And lastly, the durable power of attorney is your finances. So you're electing an agent to speak on your behalf regarding or act on your behalf regarding your finances. lists out all of their duties and responsibilities. And that is something that you have to do an extra step of once you have completed your durable power of attorney regarding your finances, that is recorded at the Register of Deeds office where you reside. That is something that's very important that it gets recorded in those offices. So those are the documents that we here at the center help develop estate planning for our clients. We also conduct seminars on that as well. So I do want to open the floor for any questions someone may have about either one of those documents.
How is the durable power, is that what you said?
Yes.
Different from the power of attorney document, a power of attorney document?
Yes.
Or is it the same thing?
So there are two types of power of attorneys. So you have a durable power of attorney, and then you have a springing power of attorney. Oftentimes, people do a durable power of attorney because when it springs, there has to be, a condition or an event that takes place for it to spring into action. So, and oftentimes when those decisions need to be made, those steps to make sure that that event sprung into action kind of delays the maintenance of those things. So, and again, that's with your finances. We're not talking about your health care. So the durable power of attorney, springing power of attorney is with the financial aspects of maintaining those assets. So I recommend durable power of attorneys just because the challenges or loopholes that you may have to engage with to make sure that that agent can do those actions under that could cause some delay in maintenance.
Do you take appointments for that?
Yes.
Thank you, Brianna. I took advantage of the service, and when I did my will, I still have not done the attachment part. That was very important, all different items that you might want to give separately from what you're saying about the power will. And that's the first thing I think you should need to address. And then about the drive-in will. I couldn't understand that because you hear about the drive-in weddings in Vegas, and I said, how are you doing a drive-in? Because I know for me it took 2 hours.
Yes.
Yeah, so.
I can definitely elaborate on that.
Yeah, both of them, thank you.
Yes. So when we draft wills, like I stated before, we cover all the bases. We talk about what you currently own, what you could acquire in the future. We talk about lapsed legacies and heirs property, but also we have an addendum or a memorandum that we attach to the will. And basically this allows you to itemize specific personal property. So this has nothing to do with land, but within our wills, we address personal property, and you can state if you want your personal property to go to one person, and the bulk of that will go to that one person or whoever you designate. But if you want to set aside your personal journals or like rings or photos, you can itemize that using the memorandum that we attach and make sure that each person gets after their consultation. The other thing I do want to address is the drive-through wills clinics. So that's something that was established due to the pandemic. The Center for Heirs Property wanted to still maintain the mission and value that we see in our landowners and in our communities. And we say, how can we provide direct services in a less direct way that will put people in harm? So we established online presentations. We started doing online seminars, and we noticed that nothing was open, but there were parking lots. So we decided that, hey, if we conduct appointments over the phone, make sure that these individuals have capacity, we talk about how they want to devise their property, we can draft these documents, meet with them in the parking lot, and they can walk away with a valid will. So that's where drive-through wills clinics kind of birthed out of, is making sure that we can still reach our communities by making sure that we don't put them in harm's way. Because that was a time where having a will was very important, and we didn't want to turn away from our communities when we saw that there was a need for that. Something else I want to talk about is non-probate assets. So As far as cash accounts are concerned, like your checking and savings accounts, those are things that you can list beneficiaries for, so they don't have to be tied up in probate. So contacting your bank, letting them know that you want to name a beneficiary on the account, those assets will be paid directly to those beneficiaries if they're named on those accounts. Insurance policies, things like that, as long as you list beneficiaries and the 100% of the policy is paid out to those beneficiaries, they do not go through probate. And you can do the same thing with any other electronic cash assets or bonds or anything like that. I also want to talk about joint tenancy. So oftentimes we see people that hold land with joint tenancy. Often that language looks like John and Ann with rights of survivorship. Now, the thing with that is that obviously someone has to survive. And so what happens with that conveyance is once one of those people pass away, you file that death certificate with the Register of Deeds office, and that makes sure that that tenancy ends and that person is the owner of record. And so that's one way that could go through the probate process, that you can avoid the probate process, is with those joint right of survivorships. Now, again, when you hold property with joint right of survivorship, no one knows when they're going to pass away. So both parties do need to have a will in place. In the event that something happens, it's already designated where that property interest is going to go, whether one person survives or the other. There's other ways that property can be held or transferred that a lot of people have taken the opportunity to do. I've seen more recent in their wills is life estates. So they would leave a life estate for their loved one and then transfer the remaining interest once that person passes away to another party. That's something that we like to discuss also during our appointments, is how would you like the property to be held? Because we don't want to create an heirs property situation by giving it to all 6 children or all 5 children. So those are things that having an attorney walk through you to discuss with you your intent of how you want your land to be transferred. Also, you can itemize or specify how you want the property to be used. And like I said, your forest management plan can be referenced in your estate plan.
I have a question.
Yes.
My question is, when does a power of attorney goes into effect?
Your durable or healthcare power of attorney?
Let's say not healthcare.
Your durable? Yes. So your durable power of attorney is active when it's signed and witnessed, because it's a durable power of attorney. It's active then. You are going to want to record it at the Register of Deeds office so that it is of record that you've made this document and this is the agent that can make those decisions on your behalf. But it is enforceable when signed. Now, that doesn't mean that agent can override what you have decided for yourself, because they have to act in your best interest. But it is effective once signed. And it's only, most times it is used to, when you lack the capacity to make that decision. And so what that means is if you're not in the States, that agent can act on your behalf. Those things, but also if it's more of a serious condition where you don't have the mental capacity to do so, they'll be able to act on that power of attorney. But when it's in a longer extent of time, that's when you go through a conservatorship or guardianship approach. So when the more extreme circumstances, when it's more of a permanent incapacity, that's when you go through a guardianship, which deals with health care. That's through the court process, where a guardian is appointed for that permanent incapacity that that person may have. And then a conservator is that conservatorship through the probate court, where those finances will be handled when it's a permanent incapacity.
So essentially, if I understood what you just asked, what you just explained, if I made, say, one of my sons, give him power of attorney, they can sign documents or whatnot in my behalf the moment that is filed with the court.
Yes. With the Register of Deeds, not the court.
Yes. That's it.
Yes.
The power of attorney
ends with the death of the person, does the durable power of attorney also end with the death of a person?
Yes, so those are, thank you for asking that question to clarify. Yes, so advanced directives are, I like to think of living documents. So their termination, if that person did not revoke their agent's privilege, will terminate at their passing. So, a will is valid when you sign it. However, a will is not enforceable, or it doesn't take root until you pass away. So those are the distinctions that I do appreciate you helping me clarify that.
One last question. Yes. How do you deal with issues where you have family members who are older, who live out of state, but still have interest in property in South Carolina and would like to or need to have those issues resolved?
Clarifying, has that person now deceased? No, okay. So that person needs to have an attorney in that state to draft their will, just because you want a will that addresses the law of that particular state. But it does need to reference any out-of-state property. One thing that our wills do include is a provision regarding after-acquired property, but also the need for any ancillary estates that will need to take place. So what will happen is, if any one of our testators pass away, our provision has, if they own property in another state, that gives the personal representative the power and authority to go to such state to settle their affairs in that probate court. So to elaborate a little bit more, when someone passes away with property in multiple locations, they need to open an estate where that property resides, so that that property transfer can happen through that probate court.
Last question.
Okay.
Promise. If the person has handwritten what they call a will, and had it notarized, or maybe not, is it legal? Or does the law recognize it, or things will still have to be probated?
So the requirements is that it be written, so it can be typed or written, signed by 2 witnesses that are disinterested. That makes a valid will. It makes it self-proving for it to be notarized, but that's not a requirement. So as long as it's written, hand or typed, signed by the testator and 2 witnesses, it's a valid will.
Signed by 2 witnesses or notarized by a person, either or both?
No, both.
Okay.
Cover all bases. I don't want to be, did anyone have a question on this side? I was being a little generous to.
The tax situation, the state taxes, can you explain that a little bit? That's too much.
So,
Can we just make sure we ask all questions into the microphone so the people who are watching it?
yes. So, did you want her to repeat the question? Please repeat.
As far as the estate taxes go, when do they apply and how much is it, based on what formula?
So formula, can't tell you that. The courts calculate that formula as far as the fees that's going to be attached to it. But anything over $500,000, we like to tell people to, we do basic wills, so we don't address those tax implications that can come with estates that's over $500,000. So we do recommend getting a more getting a tax attorney to explain other means of making sure those property assets are distributed upon your passing, whether that means creating a LLC or a trust, because once those assets are in those entities, they don't go through the probate process because they're not titled in an individual or a human person's name. So those are things that that should be considered if you know you have assets that amount to over $500,000, is that there are going to be estate taxes that may be more than your family could pay for without selling those assets. So we do recommend We do consultations, they're free, so if anyone's interested in talking to a staff attorney about those things, it's a 1-hour consultation just to get a little bit more guidance on that as well. One moment, let me get you a mic. Oh, sorry.
Yes, I had the question. Once you all draft a will, the attachment sheet, when they list all the other items that they would like to have dispersed upon family members, does that have to come back to your company to be notarized?
No, so that memorandum is basically handwritten. One thing I recommend is if you leave any blanks, kind of black out any blanks so no one can go behind you and write in it, of course. But you write in your individual personal items, name the beneficiary next to it, and then sign and date the bottom. But you want to make sure that it remains attached to the will. No problem.
Yeah, when you own property in several counties in the state of South Carolina, you have to probate in each county or just one county?
No, so you do, in the probate process, there's a deed of distribution document. And so you have to address where that property is situated in that particular county. So say I have a family member that lived in Charleston County. They have property in Charleston County, in Colleton County. Those estates will that estate will address 2 different types of ROD offices that have to show that this will was filed with the court, and this is how this property in Charleston County was to be distributed. This is how the property, I guess, in Colleton County was supposed to be distributed, and that gets filed at the Register of Deeds office for each respective property, because that's where that original deed showing that deceased person owned the property. So you want to have that clear chain of title in the probate court and in the Register of Deeds office. So both sectors know, because in heirs property we have complex resolutions that end up needing a quiet title action. So through that title search, you're able to see this person passed away, this is what happened through the estate, this is what they owned. So that's why it's filed with the Register of Deeds office as well as the probate court.
Thank you. So we have several questions from online. One says, if the person was deceased more than 20 years ago and there's only one child living in another state and is paying taxes, is there a way to do a silent protest to gain ownership without probate?
No.
All right. And that question has been answered.
But I'll give a detailed answer. But to answer the question, no. So in South Carolina, you can only probate a estate within the first 10 years of their passing. Once that time has lapsed, there's another process that's called a petition to determine heirs action. That action is also housed in the probate court, and basically what will happen is it is determining the heirs that have rights to inherit from that estate. That is a formal hearing in front of the probate judge, and that order is in the probate court, but also filed in the probate court and recorded at the Register of Deeds office to show that chain of title from the deceased person to their heirs.
Okay, thank you.
Yeah.
All right. If a person, I already answered that one. The will is valid after its filing with the court or before?
You do not file wills with the court in South Carolina. One thing that I meant to mention, but I'm glad the question was asked, update your wills. So wills can be updated, and so what happens is when you update your will, you are revoking the previous will. The reason why you want to update your will, life happens, you acquire more property, you may have a child, you may have grandchildren, you may have a deceased spouse now, so you want to make sure that they are up to date. Now, you want to keep it in a safe place because once you pass away, your personal representative then files it with the court. So you do not file your will with the court after execution. You just want to make sure it's in a safe place. Some people use personal safes. If that's the case, personal safes are fireproof, but put in a Ziploc for humidity. Some people use safe deposit box, but please make sure that your personal representative has access to such box.
All right. And a last one that's in here. If a person dies interstate and in one state and owns property in a home state, which is another state, does the administrator need to go through a separate probate process in both states? Is there a statute of limitations as to when someone can claim inheritance of heirs property in an interstate scenario?
So if a person passes away in a state, that's where they were domiciled, that's where their probate is going to be open. Their stationary probate is going to be open. If they have property outside the state, that's when you have your ancillary administration that happens in that other state to address those other assets. Now, again, each state has its own laws. So there's going to be statute of limitations tied to South Carolina has 10 years. I don't really know other state statute of limitations, so it's going to be important to seek counsel in that state with someone that practices in that area to know what those guidelines are.
Thank you.
When you have joint ownership of property worth over $500,000, and then could you still put that in a trust, or still have to put it in a will?
So I like to tell people that own property together is that anyone that's on the property, so we're not even talking about heirs property, just so we clear, just to keep it clean. We're just talking about, say, two people own property together. Both people would need to transfer their interest into the trust, because what you don't want is a situation where property is being managed by a trust and a person. You want to keep it seamless. So if there's a 50-50 split between two owners, you want to make sure 100% is transferred into the trust. Now, your trust documents can outline and list how that property is to be distributed, or what assets are being distributed, or anything like that. That's something that your trust documents can definitely talk about as far as ownership and how to maintain the property. But it will be recommended that both owners or all owners transfer interest into a trust.
I have a question. What trust?
One more.
Which trust are you referring to? The revocable trust or the?
So you can choose to have a revocable trust. You can choose to have a living trust. You can choose to have a special needs trust, things like that. It's still an entity. So whatever entity you decide to transfer interest to, you want 100% interest to be transferred into that entity. Now, the difference between the trust is what you want them to do. So revocable, hence you can revoke it if you want to. Other trusts can't be dissolved and they have different restrictions. So it really depends on what type of trust you want or how you want your assets to be held.
I have a question. Under heirs property, if 90% of or 99% of the members in the family are willing to dissolve the property, but you have one that will refuse to do anything, how could you handle that when they don't pay anything into taking care of any of the responsibilities or any fines that's levied for not taking care of the property, if the ones that's there are taking care of it and have those responsibilities?
Unfortunately, you may not like my answer, but heirs property is something that they just they have rights to inherit, they have the right to enjoy their fractional interest regardless if they contribute or not. They still have that ownership interest, and although they may not have contributed or maintained or showed any interest, that doesn't negate their property rights and their interest to it. What we like to do at the center is we like to have brief service family presentations so that families do have that intimate time to have those conversations so that it doesn't become a formal dispute in the court that could result in possible land loss through the quiet title process of a partition by sale or anything like that. So that's one thing that we try to facilitate is those meetings to get everyone on the same page to talk about what their options are, how to keep the property, or what strategies as a family could be taken to make sure that the property isn't lost based on disputes that may happen or disagreements between the future of the property or how to maintain it.
If the property is lost or the ones that's communicating are the ones that's being sought by, say, the location, whether it's local or a municipal zoning board, having to pay the responsibilities or have to go to court for it, I know the fines can sometimes be quite hefty, but those others are not wanting to do anything to pay on that cost of the fines.
Yes, ideally you would, with heirs property, ideally you would want heirs to share in the profits and the losses of the property just because they have that property interest. Unfortunately, that is not the case in reality. Sometimes families aren't tied to the property, they don't feel a connection to it and don't want to contribute, but they still have that right to it. I know that there has been opportunities or discussions amongst family regarding buyouts. That is also a type of partition where you could go through a quiet title action and the family could come to an agreement to buy out heirs' interests. That is costly, just like any court action, because it comes with the title search, making sure that notice is done, publication is done, and those appraisals are done. But definitely, those are options that families do consider when there's a majority or there's just some family members that want to keep their interest in the property, others that want to sell their interest. Those are kind of some of the discussions that come about with the quiet title action as well. And please feel free to talk to me after if you have other questions about that. Okay, well, that is my time. Thank you so much.
Okay, ladies and gentlemen, we are going to do another break, this time 20 minutes, so please, you, again, with the Hoover app, if you all can, please download the app if you have not, post pictures, engage. We will come back here at 1 p.m., and again, let me know if you have any questions about that Hoover app. We're really trying to get pictures posted.